introduce our speaker, Professor Juan Mendez, who's a professor of human rights law and residence at the American University, Washington College of Law. He also is the faculty director of the Anti-Torture Initiative. He has quite an amazing life story and appointments that abound. He served as a UN Special Rapporteur on torture and other cruel, inhuman, and degrading treatment or punishment between November of 2010 and October of 2016. You should go to the website where you can read his entire bio. A couple of bullet points that were suggested by people who know him well. Importantly, he starts as a lawyer in Argentina in the 1970s, and he represented political activists. And for that service, he was arrested by the junta, incarcerated and tortured for 18 months. He was expelled from the country in 1979 and has devoted his life to working on issues of human rights. He was actually present at the founding of Human Rights Watch and played major roles in that organization going forward. His work as a special rapporteur that I mentioned included groundbreaking work, including calls for the elimination of solitary confinement among especially vulnerable populations, and applying the concept of torture and cruel, inhuman, and degrading treatment to medical practices such as involuntary sterilization. So he's going to speak to us, typically until 1 o'clock. No PowerPoint presentation, so put on your seatbelts and get ready for the lesson.
Good afternoon, and thank you, Dr. Sugarman, for your introduction, and the Johns Hopkins Berman Institute of Bioethics for inviting me to speak at this seminar series on impact and importance of health professionals' role in human rights. Healthcare professionals play a key role in the detection and documentation of human rights violations, and are often, though not often enough, unfortunately, called upon to verify the physical consequences of severe torture or ill treatment. They also determine causes of death and help identify victims buried in no-name graves. In that sense, health professionals are essential to one of the principal endeavors of the human rights movement, and that is achieving accountability and ending impunity for human rights violations. On the other hand, when it comes to torture and ill treatment, certain practices that are common as therapies, in some regions of the world, must be considered forms of abuse being committed in healthcare settings. Unfortunately, very little research has gone on to identify and denounce such practices when they amount to torture or cruel, inhuman, or degrading treatment. In an effort to shed light on this topic and to generate a debate about it, in 2013, in my capacity as UN Special Rapporteur on Torture, I published a report illustrating some of the undetected or unrecognized abusive practices that can take place in healthcare settings. I called for recognition of these abuses and for new engagement on how to promote accountability for them. The instances highlighted in that report, however, do not define the role of healthcare professionals in human rights promotion and prevention of torture or ill treatment. It is imperative that the healthcare community foster a culture of respect for human rights and become accountable to uphold the highest standards of the professions. The healthcare profession is based on service to individuals in some of the most dire moments. In those moments, healthcare professionals are often the first to see the real effects of abuse. For all of these reasons, healthcare professionals are vital allies and advocates in the pursuit of justice for human rights abuses and in the promotion and protection of human rights. Severe pain and suffering of a mental or physical nature that is deliberately inflicted is what defines torture in international law. Cruel, inhuman, or degrading treatment is pain and suffering of a lesser intensity, or that results not from intent to cause harm, but from negligence or from general conditions of detention or treatment. The definition also requires that the pain and suffering is inflicted by a state actor or under instigation of a state agent or with his or her tolerance or acquiescence. It follows that certain practices can and should be analyzed under the absolute prohibition of torture or ill treatment if they do not respect the interests and wishes of the patient, or if they're not scientifically indicated, because there exist alternatives that are equally or more effective and less painful. A key component of how abusive practices in the healthcare setting can rise to the level of torture or ill treatment includes instances of forced medical intervention with at least questionable medical necessity, and in the absence of less intrusive or less painful alternatives. In such cases, the therapies cause an erosion of the concept of informed consent. It must be stressed that informed consent has entered the realm of an international human rights standard through the adoption of the Convention on the Rights of Persons with Disabilities. Informed consent can sometimes be compromised in healthcare settings due to structural inequalities and power imbalances between doctors and patients. This is often exacerbated by stigma and discrimination, resulting in individuals from certain groups being disproportionately vulnerable to having their informed consent undermined. Medical treatments that are intrusive or irreversible rise to the level of torture or ill treatment when administered without the free and informed consent of the person concerned. In the United States and around the world, healthcare professionals have played a negative role in sanctioning and sometimes perpetuating human rights abuses against marginalized groups, such as women living in poverty, the LGBTI population, the prison population, and persons with psychosocial disabilities. The mandate of the Special Rapporteur on Torture has long recognized the discriminatory character of forced psychiatric interventions and forced sterilization of individuals as conduct that rises to the level of ill treatment and violates international law obligations of the state. In my report, I highlighted several settings where torture and ill treatment can occur, including the compulsory detention of individuals for drug treatment and rehabilitation, violations of reproductive rights, denial of pain treatment, the neglect or detention of individuals in psychiatric or social care institutions, and other instances of mistreatment of marginalized groups, including persons living with HIV/AIDS, drug users, sex workers, the LGBTI community, and persons with disabilities. In many countries, the compulsory detention of drug users and other marginalized groups, including street children, persons with psychosocial disabilities, sex workers, and homeless individuals, in so-called drug treatment centers is a serious problem. Many of these individuals are placed in these centers without having received a medical evaluation, judicial review of the decision, or even the right to appeal. While in these centers, individuals frequently experience physical violence and humiliation, and are subjected to practices that amount to torture and ill treatment in the guise of rehabilitation, including forced labor, physical disciplinary exercises, like in military-style drills, electroshock therapy, and even denial of pain treatment. These practices violate international human rights law and are illegitimate substitutes for evidence-based measures, such as substitution therapy, psychological interventions, and other forms of treatment that can be administered with full, free and informed consent. Members of sexual minorities are disproportionately subjected to torture and other forms of ill treatment around the world because they fail to conform to socially constructed gender expectations. For example, lesbian, gay, bisexual, transgender, and intersex persons are subjected to ill treatment by healthcare professionals performing genital normalizing surgeries under the guise of reparative therapies, quote unquote. The requirement that a transgender individual be sterilized as a prerequisite for legal recognition also constitutes ill treatment under international law. Women may experience multiple forms of discrimination on the basis of their sex and other status or identity. Forced sterilizations and abortions, as well as sterilization with fraudulently obtained consent, are violent acts that are used as forms of social control in violation of an individual's right to be free from torture and other ill treatment. The rapporteurship also identified cases in which denial of reproductive rights cause women to suffer severe mental and physical pain. Even where abortion is legally available, young girls and women are frequently made to suffer humiliation of various sorts when they seek such medical treatment. As the European Court of Human Rights has said, humiliation is the very definition of degrading treatment, is the definition. In fact, the Committee Against Torture, as the authoritative organ of interpretation of the Convention Against Torture, has had occasion to state that absolute prohibitions of reproductive rights in domestic law are contrary to international law because they result in mental and physical torture or cruel, inhuman, and degrading treatment of some women, usually drawn from sectors of society that suffer exclusion and marginalization. Persons with disabilities are particularly affected by forced medical intervention and continue to be exposed to non-consensual medical practices. Individuals with psychosocial and intellectual disabilities frequently experience powerlessness and are stigmatized, which facilitates the potential occurrence of abuses. It is ultimately a combination of state sanctioning of these practices along with the healthcare community relying on problematic norms about legal capacity, guardianship, and decision-making that result in abusive practices that may rise to the level of torture or ill-treatment in violation of international law standards. These practices are repeatedly justified as required by medical necessity. Re-evaluating the doctrine of medical necessity is required to create a more accountable framework that does not protect professionals who commit abuses. As mentioned previously, medical treatment of an intrusive and painful nature, if they lack valid science-based therapeutic purpose, constitute ill treatment when enforced or administered without free and informed consent. Involuntary commitment and restraints, physical as well as chemical, can only be used in very narrow circumstances for a limited time and within limited means as strictly required to prevent the risk for major harm to the patient or to others. In my report's concluding recommendations, I called for the recognition that some treatments constitute abuses of the patient's rights and dignity, and for that reason they should be banned. The prohibition must elicit thorough, prompt, and impartial investigations into allegations of abuse in healthcare settings. I further called upon states to provide human rights education and information to healthcare professionals to promote a culture of respect for human integrity and dignity. More recently, healthcare professionals have been in the spotlight for their contributions to the U.S. counterterrorism policies marred by a policy of torture practices against detainees. It is important to note the contributions that some healthcare professionals made in this widespread scheme to justify torture, along with some lawyers who likewise played a key role in attempting to legitimize these practices. Neither should be absolved of their contribution because the policies would not have been so legitimized, quote unquote, or normalized, quote unquote, without their contribution. The U.S. administration's post 9/11 decision to engage in torture or enhanced interrogation techniques enlisted psychologists to design and sometimes implement interrogation strategies based on the idea of learned helplessness. Other psychologists in Guantanamo, Abu Ghraib, and Bagram monitored interrogations and advised the military on how to conduct the questioning more effectively, again, quote unquote, with the aim of breaking the detainee under the false assumption that torture yields valuable information. While psychologists were assisting in the promotion of this policy, at the same time, other professionals conducted research rendered in the infamous torture memos in an attempt to provide evidence that the abuses did not cause harm that would legally rise to the level of torture. In October 2015, the American Civil Liberties Union filed a lawsuit against James Elder Mitchell and John Bruce Jessen. Both were psychologists contracted by the CIA to design, implement, and oversee the agency's torture program. The lawsuit was filed on behalf of 3 victims of the program who were kidnapped by the CIA, tortured, and experimented on according to protocols developed by Mitchell and Jessen. One of the victims died as a result of the torture, and the other 2 continued to suffer the physical and psychological effects of being tortured. A main component of the enhanced interrogation techniques that the Justice Department approved were designed to induce learned helplessness, which is marked by severe infliction of mental and physical pain and suffering to psychologically destroy the individual in order to eradicate his or her resistance to interrogation. They were also tasked with evaluating the effectiveness of that program. The 3 victims sued Mitchell and Jessen for the commission of torture, cruel, inhuman, and degrade treatment, non-consensual human experimentation, and war crimes. In August of 2017, on the eve of trial, the psychologists agreed to a settlement. Though the full terms of the agreement are confidential, it is significant that the case was even going to go to trial. Prior to this, every lawsuit trying to hold people or companies accountable for their participation in the CIA programs of illegal detention, extraordinary rendition, and torture had been dismissed, as the Justice Department argued that each case would reveal state secrets. It is important to note that at first the American Psychological Association defended Mitchell and Jessen and refused to condemn psychologists' participation in the so-called enhanced interrogation techniques. However, the APA eventually adopted an institutional policy condemning such participation and enacted ethical rules to the effect that such contribution constitutes a breach of professional standards. This was only after substantial pressure from activist groups and the APA's own membership and community. Specifically, Dr. Stephen Solz, a clinical psychologist and psychoanalyst, was a strong critic of the APA's support for Mitchell and Jessen and pioneered the demand for institutional accountability. He has been a leading voice in the movement to remove psychologists from abusive national security interrogations and change the APA's permissive policies that allow their involvement in the first place. In 2007, Solz publicly challenged the APA to ban the involvement of professional psychologists in interrogations. They did not instill a ban at the time. However, in 2015, after the release of the Hoffman report that was commissioned by the APA and documented the collusion between the APA and the Defense Department, the organization finally voted to remove all psychologists from detention sites and national security interrogations. Dr. Solz's activism and that of several other health professionals continues in the uncertain climate of the current administration and its intention potentially to revive the use of enhanced interrogation. I was privileged to hear them recently at a public hearing in Raleigh, North Carolina, organized by the North Carolina Commission of Inquiry on Torture, a citizens' initiative dedicated to bringing to light the participation of North Carolina companies in extraordinary renditions. Although the Mitchell and Jessen case has provided great visibility to the participation of healthcare professionals in torture, it must be noted that for a long time and in many countries, doctors enrolled in law enforcement agencies have also participated in torture sessions to determine, for example, how much more pain can be inflicted on a detainee without killing him or her. They have also assisted clandestinely detained women in giving birth, knowing that the baby would be given in illegal adoption to a family and the mother would be killed and her body concealed. In the Nazi regime and later in places like South Africa, doctors have engaged in experimentation on detainees or covered up clear signs of torture. In many other countries, doctors forge medical certificates to conceal the true nature of the lesions and the treatment inflicted on a detainee. Even more routinely, prison doctors are asked to evaluate an inmate's state of health before being placed in solitary confinement. The latest version of the UN Standard Minimum Rules for the Treatment of Prisoners, now called the Nelson Mandela Rules, have incorporated more precise standards as to the prisoner's right to health care and for the ethical discharge of doctors' duties in regards to persons deprived of liberty. Most recently, these negative stories are increasingly recognized by the international community. Visibility is key in the pursuit of justice for victims of abuse by healthcare professionals, and all in that role are called upon to evaluate the practices of their own communities. Healthcare professionals are vital not only in the healing process for victims, but as advocates. Indeed, they can play a significant role in diagnosing human rights abuses and preventing practices by abiding by protocols to report on such issues. The example of Stephen Solz shows how significant activism among healthcare professionals can make effective change. Physicians and psychologists have also played important roles at the Guantanamo Bay prison and the struggle to end the abuses there. As authorized advisors to the legal defense teams of the inmates that are held at Guantanamo, doctors and psychologists have provided valuable scientific expertise and to document specific acts of torture. In addition, doctors have played a significant role in drafting international standards that require their scientific knowledge and experience, such as the Minnesota Protocol for the Investigation of Extrajudicial Executions, which has been updated in the last couple of years, and the Istanbul Protocol on the Detection and Documentation of Torture. For the last several decades, doctors, psychiatrists, and psychologists have also advanced the protection of human rights by rendering powerful expert testimonies in domestic and in international litigation. Finally, since the 1970s, doctors and other health professionals have created institutions in many countries dedicated to the treatment of torture survivors and to the advancement of the highest standard of professional ethics of their profession in the pursuit of a world free of torture and abuse. One of the key documents addressing the central role that healthcare professionals can play in detecting and preventing torture is the Manual on the Effective Investigation and Documentation of Torture and Other Cruelly, Inhuman, or Degrading Treatment or Punishment, also known as the Istanbul Protocol. This non-binding document was developed in 1999 and adopted a few years later by the UN General Assembly. It represents a standard by which the international community can assess if a state has conducted a comprehensive, impartial, and independent investigation of allegations of torture. And the document is also the means to ensure that states comply with their obligations to investigate, prosecute, and punish torture, and to do it in good faith. It is also the main provision by which we hold states to their obligation to exclude from any and all proceedings any confession or other evidence obtained under torture. The Istanbul Protocol is primarily a framework for accountability and for the effectiveness of the rule of law. It empowers civil society, and in particular health professionals, to proactively document and investigate signs of torture or ill treatment and to bring them to court. It is important to note that the Istanbul Protocol is a standard focused on gathering scientific evidence, which in many cases holds decisive weight in the prosecution of allegations of torture or ill treatment and in the exclusion of torture-tainted evidence. Obviously, in 20 years, the science has advanced on the detection of torture, and so some voices are calling for an updating of the Istanbul Protocol, but certainly without undermining its enormous value for human rights promotion and protection. Generally, the Istanbul Protocol is an invaluable tool to ensure that quality reporting requirements are met to bring perpetrators to justice. The protocol can also be used as an advocacy tool to train health professionals to make sure abuses are investigated and punished. It also has guidelines on the early detection of certain types of torture or ill treatment. Also of particular interest are the ethical standards that are specified as an annex to the Istanbul Protocol, and the dual role that a professional might confront in detention settings. Some medical professionals can have dual obligations to their patients and to their employers. The protocol recognizes the dilemmas arising from these dual obligations, particularly when professionals are, and I quote, working with the police, military, or other security service or in prisons, end quote. When the interests of employers and their non-medical colleagues may be in conflict with the best interests of the detainee patient. However, the protocol affirms that whatever the circumstances of employment, all health professionals owe a fundamental duty of care for the people that they are asked to examine or treat. They cannot be obliged by contractual or other considerations to compromise their professional independence. They must make an unbiased assessment of the patient's health interests and act accordingly. Perhaps the most important provisions in the Istanbul Protocol are the requirements of safeguards for the independence and impartiality of health professionals who render expert scientific evaluations to aid the courts in determining whether torture has occurred. The current chair of the United Nations Committee Against Torture, Dr. Jens Modvig, a Danish physician, has emphasized the need for independent medical professionals in settings where individuals may be at risk of torture or ill treatment. The potential for dual obligations highlights the need for independent medical care, especially for individuals in detention who may experience torture but are only allowed medical treatment by state medical professionals. During my mandate as a special rapporteur on torture, I also emphasized the need for independent medical professionals in the context of forensic doctors who often serve under law enforcement or security agencies. In these cases, it should be mandatory for the detainee to receive an independent and impartial assessment. In my country visits, to which I was always accompanied by a highly qualified forensic doctor, we found that forensic evidence of torture was severely lacking around the world. There seemed to be a tendency to avoid, during forensic examinations, to produce flawed or even fraudulent reports, or to disregard them in the rare instance when serious reports were present. In response to these observations in 2014, I published a thematic report on the importance of independent and properly collected forensic evidence in efforts to combat impunity for torture. The proper implementation of the high standards in the Istanbul Protocol and the use of independent forensic evidence are vitally important to effectively investigate, prosecute, and punish torture and ill treatment. By way of conclusion, let me say that healthcare professionals play a central role in the detection and proper documentation of instances of torture, and it is vital that all health professionals be trained in the Istanbul Protocol and know how to utilize it properly. It can be vital to the fate of victims of torture and can transform a health professional's role from one of not only therapist but also advocate for the victim. A positive healthcare setting can be a powerful tool in victims' personal journeys to rehabilitation. Despite the instances of complicity with and partaking in abusive practices by medical professionals, a shift is taking place in the healthcare professional community. Healthcare professionals are key partners in the fight against torture, and they can and must play an important role in the detection of human rights violations. It is imperative that young healthcare professionals continue to identify and combat impunity within the field for individuals who participate in abusive practices, and further to advocate for policies of accountability and support training in the detection and prevention of human rights violations. Thank you. I understand we have some.
Yeah, so we have time for questions. Professor Mendez says he'll take questions on his own, but the floor is open for questions, and Pete will bring the microphone if you raise your hand.
Hi, thanks so much for your talk. I'm Alexis Walker. I'm a postdoctoral fellow here at the Berman Institute, and I wondered if you could speak a little bit about the reception of the 2013 report and influences that it may have had.
Yeah, thank you. Yeah, that's a good question. I didn't have the space or time to elaborate on it, but I do want to say that that report was received with quite a bit of controversy. At least some parts of it was, I mean, not the most egregious types of violations like forced sterilization and, you know, denial of reproductive rights in cases where the law allows it, because those were well known. But the report also had some editing problems, and seemed to be contradictory on one issue, which is this question of forced medical interventions, especially against people with psychosocial disabilities. And I got flack from both the psychiatric community and also from groups that call themselves users and victims of psychiatry. On the one hand, because I I called for a review of the laws about under what conditions, interventions can be done and should be done without proper consent from the victim. And on the other hand, because I also allowed for some interventions under very specific circumstances to be done without consent. And I had to clarify that. I did clarify it. I got a letter from the World Medical Association, and I also was invited to speak at the German Psychiatric Association. I have to say that the debates were all very urbane and serious, but I had a chance to clarify. And the point is that the international law is shifting rapidly here. The Convention on the Rights of Persons with Disabilities is very new, and even different instances of human rights protection internationally don't quite agree on what exactly the Convention allows and what not. For example, the Committee on the Rights of Persons with Disabilities, it is the implementing organ of that convention, takes a very radical position saying that no intervention of any kind without the free, full and informed consent of the patient is now allowed by international law. Whereas the Subcommittee on the Prevention of Torture, for example, drafted a series of guidelines as to when non-consensual intervention may be justified in the psychosocial realm. I also think that the Subcommittee on Prevention of Torture position is more or less more of the same, and I do think that they are wrong, that the law is changing and must change, with the paradigm being that patients don't ever lose agency, and we have to find a way in which we address questions of people being declared insane, and therefore all their rights are taken away, and someone makes decisions for them, and that someone sometimes is a director of a mental health hospital who cares for 250 people and has the same answer for all of them. I think the law is changing in that way, and we don't know exactly where it will fall. But I do believe that these groups of users and victims, as they call themselves, of psychiatry are wrong in saying that nowadays the only treatment that is available is that one that the patient, him or herself, decides with free and informed consent. Because there are instances in which it's just not possible to let people hurt themselves or others. But what my report did say is that we need a standard that says, in a very narrow way, when it is legitimate to depart from consent. And I, more or less, of course subject to much broader and deeper discussions, I identified that as when the patient is at risk of self-harm or harm to others, and then only for the time and with the means strictly understood to address the harm and nothing else. Again, subject to further discussion. But I'm glad for the question. It did raise controversy, but that's what reports are for. I mean, they're not meant to say this is the law everybody follow. They're meant to generate a debate. And in that sense, I'm very happy about it. And I have to say that many health professionals and other communities supported the report and helped me clarify it and have continued to debate it, although it's been now 5 years. Thank you.
Hi, thanks for your talk. I'm Gopi Prasad, a professor at the Berman Institute. So I'm interested in this language from the UN definition of torture as usual. When I read these UN pieces of language, I find a lot of really normatively weighty language that's sometimes hard to understand how to interpret. And so I'm curious about, in particular, what the intentionally inflicted requirement in torture is supposed to mean, and how broadly we would want the definition of torture to extend, as opposed to it being a narrower definition and then us recognizing other forms of wrong that might be committed against, say, patients, such as violations of informed consent or other ethical obligations. So I'm curious whether, in particular, the intent, the specific intent, has to be the point of what you're doing is to inflict pain or suffering, or whether it just has to be that the act is intentional. It's not just some kind of mistake, but you know pain and suffering is a side effect. So here's an example I was especially interested in, is that say that the state permits, acquiesces in physicians performing surgery using more painful methods in certain, especially maybe if it's in certain population subgroups. And there are various reasons, maybe they can't afford to pay, maybe physicians have some sort of belief about the evidence base. And I'm interested in whether that sort of professional norm could end up falling descriptively within the definition of torture, and then sort of ethically, whether you think it makes sense that the term torture would cover cases like that, as well as what I think sort of colloquially people think to be these sort of core cases of torture where somebody has pain inflicted on them, say, for the purpose of extracting a confession, or purely to punish.
Good, thank you. Well, the law is generally vague and abstract, but we do understand it better when courts apply it. And my sense is that the international law definitions of torture are quite manageable, quite apprehensible, as long as you follow interpretations done by courts on it, and particularly authoritative courts, obviously. The requirement of intent has sometimes been confused with the requirement of purpose. The definition includes both. But, and for example, in the torture memos, I think deliberately, these lawyers were, knew better, deliberately mixed up purpose with intent and said, it's not torture if you want to save the country. It's not torture if you are avoiding, a major harm like a ticking bomb, etc. The point being that the intent is related directly to the intentional inflicting of pain and suffering. If you know that you're deliberately, making the person hurt, that's enough to satisfy the intent. The purpose for which you do it can be more or less aggravating. So, for example, if it's only for punishment, that's of course, that is impermissible, but it's also impermissible if it is for the purpose of interrogation. The thing about the report on torture and healthcare, first, the question of official acquiescence or state agent acquiescence is satisfied in all kinds of healthcare situations, because even in a private clinic, the state authorizes or regulates the medical professional anyway, so the state is always involved. So, but most of the abuses that we identified happen in public hospitals anyway. Now there, the question of intent and the possible, because if you know that you're hurting somebody, but you're doing it for a higher purpose, then does that, still constitute torture? And I feel that there's where the questions of medical necessity, and that's your field, not mine, come into play. Because if you have available to you a form of therapy that is available in the community, I don't mean in the Mayo Clinic, I mean in your community, and you still use one that is unnecessarily painful, you may be, and you know that it's painful, therefore the intent component is there, then it may be cruel, inhuman, and degrading treatment to embark on it. Now, obviously, every intervention is painful in one way or the other. So, and that's why the other component of consent comes into play. But the international law requires that the consent be free, full, and informed, which means that the patient has to know whether there are other alternatives and has to decide for him or herself whether he nevertheless wants to go with the painful treatment because for a higher purpose, for curing himself or getting healthy, he or she decides that that's the best course of action. I'm not sure if I answered all of your question, but I've tried.
Other questions? So I'll have a question while people are thinking. A lot of researchers here at the School of Public Health and in the School of Medicine do work with populations around the globe that are at risk for HIV infection. People who inject drugs, men have sex with men, and the like. And they're in the same situations which you touched on briefly, where the governments in different nations will apply a set of punishments, tortures, treatments that are not evidence-based. And the question is, in the process of doing this research, researchers here of all sorts are trying to bring light to the problems that are going on and trying to develop and test interventions to try to prevent different kinds of badness from happening to folks. There are occasionally claims that that sort of research makes the researchers here complicit in what the governments are doing rather than playing another role. And I wondered if you had any comments on the role of complicity.
Well, I mean, I think the question of complicity, I mentioned very in passing that the Nelson Mandela rules, the standard minimum rules on the treatment of prisoners, now have detailed rules on what prisoners, anybody deprived of liberty, more generally, is entitled to in terms of medical care. But they also establish the need for independence and impartiality, and more specifically, prohibit the intervention of doctors in situations in which their professional advice may lead to either treatment or either torture or ill treatment. The example I mentioned in the remarks, mostly because it's closer to me, because I also did a major report and I'm still advocating on the regulation of solitary confinement, is that some states say, well, it can be bad, it can be torture, because we have doctors determining first the state of health of that person and whether they can take solitary confinement. Take is my word here, quote unquote. Now, if the treatment is going to be painful, and in this case it's mentally painful, that the doctor advises, yeah, this guy is okay, makes him complicit in the ill treatment. Now, obviously, you don't want people being sent to solitary confinement without even a medical evaluation, but it's a very tricky ethical area to say, we provide for some safeguards, and that safeguard is the medical professional's advice, or one of them. I'm not saying that solitary confinement should be banned completely. What I call for is a ban on prolonged and indefinite solitary confinement, and a ban of solitary confinement or even hours on people with mental disabilities or psychosocial disabilities, on women who are breastfeeding or pregnant, and on juveniles, children of any age under 18. And that was basically based on the psychiatric and medical literature about how people experiment isolation. And all of those rules have been incorporated into the new Nelson Mandela rules. Again, I think there are positive roles to play by because a lawyer who represents the state will also be complicit in the torture if he says, this person is a member of a gang and therefore has to be in solitary confinement. But exactly where the ethical rules are drawn is something that exceeds me, quite frankly. As I said, I would be guided by the Nelson Mandela rules, but also by the Istanbul Protocol that says, that very specifically, includes some ethical rules for the health profession.
So this is great. So imagine a situation where someone, I'm sure there are people on one side who say these rules are the greatest thing that's happened in this setting, and others say they're insufficient to capture the plight of people who are exposed to solitary confinement. And someone raised money and said, we'd like the researchers at the Johns Hopkins Bloomberg School of Public Health to assess whether in fact these rules are sufficient in protecting the rights, interests, and welfare of people. So imagine the researcher comes into the setting, and the only way to do it is not extrapolating from literature of solitary confinement, from the hypothetical, but to study in the actual setting. The role, I guess, would be with the researchers, because they're going into the study, into the actual setting in which solitary confinement is taking place, would they be judged to be complicit with the very act of confinement itself, or would they be seen, or would it be appropriate to see them in the role of someone trying to draw light to whether or not there's still a problem?
Well, I mean, rules are never completely sufficient. I mean, the rules are legal rules. I mean, are living documents. You have to adapt them to realities, and so you can't ever say that the Istanbul Protocol is the gold standard and doesn't require any adjustment. The same with all the other instruments that I've been mentioning. So, an effort to update them, to bring them more in line with what really happens, but especially to bring them more in line with the prohibition of torture and of cruel, inhuman, and degrading treatment, and to refine the standards in which torture or ill treatment is avoided, is certainly not only perfectly legitimate, but it's actually required, and it would be a great service to human rights to have doctors doing that. Now, if I understand your question correctly, it's one thing to look at texts and read bibliography, which is what I do. Well, not only what I do, but and it's another thing to be based on research that's done, with human experimentation in place. Now, for example, the psychologists that I have followed on solitary confinement, Haney and Gressian and others, they talk to people in solitary confinement all the time. But when they come out of talking with them, they are advocating for more humane treatment and for abolition of practices that hurt them. How can that be unethical? Of course it's not. I guess it really depends on whether you're using, and here, you know this a lot better than I am, really in shaky ground here, but if you're using documentation that has been gathered by experimentation on live human beings, even if you're using it for other purposes, that may cross an ethical line, and I wouldn't know exactly where to draw that line.
That's great.
Silence is being complicit. Just the knowledge there is a torture next door to you, or silence is basically you're committing. If you see something unethical done next to you or surrounding you, even though you don't participate physically harming that subject, you are complicit, and therefore you are as guilty.
Yeah.
You are at least trying to cleanse his complicity by advocating later on afterward. But in my book, just the fact that you're legitimizing the process of torturing them, you're making it more scientifically and culturally accepted.
Yeah, and I agree completely, and it's not just moral complicity, it's legal complicity also, because, say, a prison doctor is a state official. If all officials of the state are duty-bound to denounce any human rights violation that they find, any illegal activity that they find, just as they have to denounce, you know, smuggling drugs into the prison, they also have to denounce, but that's the legal part of it, but I completely agree with you with that. We were actually talking about something that's not just silence, but actual more active participation. And again, I would really differentiate with what the purpose of the research is.
That's great. So shifting gears just a little bit, you mentioned a couple of times the need to educate healthcare professionals so that they could be aware of these issues and interact. What do you imagine that would be, or are there good examples of training programs that exist, and how do they work?
Well, I'm familiar with some of them. There may be many others, but for example, with the support of the International Bar Association, there are ongoing training sessions for healthcare professionals, but also for prosecutors, for defense attorneys, for example, about the Istanbul Protocol. I participated in them in Mexico and in Brazil. I know they happen elsewhere. There is also these institutions that I mentioned, one of them chaired by the present chair of the Committee Against Torture, Dr. Jens Modvig, a group called Dignity, it's called now. It used to have a name like International Rehabilitation Center for Torture Victims in Copenhagen. Those groups not only advocate and not only rehabilitate victims of torture from around the world, but they also train. They also provide some forms of training. Here in the United States, similar organizations, smaller I think than the Copenhagen-based group, there's one in Chicago, the Culver Center for Torture Victims. There's some work done in Los Angeles as well. Out of Harvard, there's been some very good research and work, and I suspect that there's some training going on there as well.
Yeah, I think something like this, in terms of Govin's question about what we understand in the common parlance of torture versus some of the practices that go on that might fit a definition but aren't, they seem to be the same but different. Might be a way to get them into medical schools and nursing schools a little bit easier because there's probably the unrecognized uses that are more widespread. It's just a hunch.
Yeah, I mean, again, the report on torture in healthcare settings, you know, kind of walked over a very difficult line there, again, with the purpose of generating a debate. But it was a way of calling attention over practices that, you know, we may find normal, quote unquote, especially found normal in some other countries, not here. And that, you know, we are unaware that in fact they may meet the definition and therefore, you know, need to be revised.
That's really helpful. Time for a last question? If not, please join me in thanking Professor Mendez.